Welcome. My name is Jeff Gottlieb. I'm a special education attorney located in Southern California. Today is the beginning of a series of YouTube videos on the subject of special education law. We will begin with highlighting about 6 areas of special education law such that you can use this information as parents of a special needs child to be more effective in an IEP meeting, gain the appropriate placement and the appropriate scope of services for your child. You do not need to take notes for this meeting today, for this discussion. You can simply go to my website at www.specialeducationattorneyatlaw.com. Again, that is www.specialeducationattorneyatlaw.com. If you have problems accessing my website, simply give a call to my office at 562-699-2412. That's 562-699-2412. When you go to the website, what you want to do is go to 2 tabs, click those tabs, and print out the information. Those tabs are titled, the first one is IEP Law, the second one is IEP Prep Checklist. I do want to make you aware that today's discussion is about federal and California law. So if you are located in another jurisdiction, you may want to speak to an attorney in your particular state or do some research on your own. Anyway, let's begin. The first thing I'd like to talk about is that when you receive notice of an IEP meeting, it will have a date and time on there. By law, federal law in fact, it's supposed to be at a mutually agreeable date and time. So if you find that upon receiving the notice from the school district that that date and time will not work for you, contact the school district and reschedule it. You don't want to be in a rush. An IEP meeting should not be scheduled 2 days from the date of the notice or 3 days. And it needs to be at a time that you can be there. So make certain you contact the school district. Highly recommend over the phone and in writing. And the writing should be faxed over to them as well as mailed that the time they propose will not work. Let's go on to the next subject. The next subject is your right to record an IEP meeting. You have the right to take a tape recorder. A tape recorder you can get from Staples or from Office Depot, and you can record the IEP meeting. Highly recommend that you do that. The reason is quite often you're doing your best at an IEP meeting to listen and to take notes, but it is not possible to absorb all of the information presented at an IEP meeting. So I highly recommend you take a tape recorder with you. In California, it's required that you first give 24 hours written notice that you will be taping the IEP meeting. So what I recommend that you do, as soon as you receive your notice of the IEP meeting, please let the school district know in writing that you will be recording the IEP meeting. The next thing I want to talk about, the third item here, is that as parents, you have the right to receive all new assessments to be reviewed at the IEP meeting prior to the IEP meeting itself. So what I highly recommend you do, again, when you receive notice of an IEP meeting, let the school district know in writing that you will be requesting that all new assessments be provided to you 3 days prior to the IEP meeting, and that if they are not presented to you 3 days prior to the IEP meeting, that you will be requesting that the IEP meeting be rescheduled. The reason you want to review this information is that typically the school district has had the IEP assessments prior to the IEP meeting. So they've had the opportunity to review that information. You need the opportunity to review that information, digest it all, understand what the assessments conclude, and develop your set of questions for the IEP meeting. The next thing that I want to go over, item number 4, is that you as parents have the right to your child's entire educational file. In California, at any time that you request your child's educational file, the school district is required to provide you with that file within 5 days of your written notice requesting it. Now that usually is interpreted to mean 5 business days, and that's okay. That will include 1, all the IEPs, that will include all the assessments, that will include your child's report cards, and perhaps any other notes that the school district has taken. The reason you need this information, in order for you as a parent to be well prepared for an IEP meeting, you need information. And a lot of that information comes from prior IEP records, including, like I said, the assessments, report cards, etc. The next thing I want to go over is what's called the snapshot rule. The snapshot rule is that a school district is only responsible for what they know and have as information. So, for example, if you have information as a parent which would lead a school district to come to a decision favorable to your child, and you do not provide that information to the school district, and the school district would not have had that information otherwise, the school district is not responsible for coming to the wrong decision. So if you have information that would lead the school district to the right decision, definitely share that information with the school district. The next concept and last concept I want to share with you is what's referred to as stay put. Stay put is basically the power to say no. A lot of the power in the IEP actually belongs to the school district. The parent has actually two sources of power. One is to litigate against the school district, and the other is simply to say no. Give you an example. Let's say the last agreed upon IEP stated that your child was to receive 2 hours per week of speech and language services. The school district is now proposing 1 hour. If you refuse to consent to that 1 hour, the school district is required generally by law to continue providing the 2 hours, even though you have not agreed to the 1 hour. So the power of this is that the school district only has basically 3 options in which to go from the 2 hours to the 1 hour, as an example, using stay put. One is they could negotiate with you for something else, they could get your consent, or they could litigate against you. But you've made it difficult for the school district. So bottom line is that any time the school district proposes as part of its offering a placement or scope of services that you disagree with, simply do not consent to those particular items. And that way, that will give you the opportunity to negotiate with the school district or to litigate against them for what you actually want. I want to thank you for your time today. We've gone over 6 key areas of IEP law. Hopefully this will be helpful for you to get the services and placement that your child deserves. And we will be offering more information in subsequent YouTube videos. Thank you very much and have a good day.